Hi, this is Jen Rubin, editor-in-chief of The Contrarian. Happy to welcome Andrew Weissmann back. It is the meeting of the turtlenecks today, I suppose. So we got the memo. Uh,
Yes.
James Comey, Andrew. This, as we were saying, is like a law school exam. How many things wrong with this prosecution can
It's
you
it's
find?
it's so funny. That's in law school, for people who have not been to law school, there's something in exams called an issue spotter. And there's like a long paragraph, sometimes two or three paragraphs. And what you have to do is sort of avoid the red herrings and figure out like how many issues are there and how would you analyze them. And you're right. But you know what it's such an interesting thing to talk about because this is such obvious direct weaponization. And the president, by the way, has just continued while this motion is pending, saying, "Oh, let's just go after Democrats." So, I mean, he keeps on providing more and more ammunition,
Yeah,
and so that's sort of the outrageous part. The good part, the reason this is an optimistic story, is I think the technical legal term for what's going on is a shit show. Um,
yes,
I mean, I mean, it's so unbelievable. We are back to Trump 1.0, where the malevolence is matched by the incompetence.
correct, correct. So
So
let's
pick
start.
your
Pick one
yes,
of them.
pick your
Yes, pick one of the eight reasons.
okay,
Let's start
okay,
with the issue of her appointment and of the vindictive prosecution,
sure,
and then we can go down the next level to all of the problems that she created once she was there.
sure. So look, the issue of her appointment is one that is being litigated across the country
Right,
because Donald Trump can't follow the rules. And the normal rules that every Republican and every Democrat president has followed is they appoint somebody who is qualified. If for some reason they do not get their nomination heard by Congress within 120 days, under a statute, it then goes to the court. The judges in that courthouse get to choose the person. Almost invariably, because the president has chosen somebody qualified, regardless of policy, the judges don't weigh in on policy. The person who has been waiting for 120 days, who just didn't get their hearing, is appointed by the judges. So they just
right.
continue, but now the judges have chosen. But what has happened here is you have people who are grossly incompetent according to the judges. By the way, bipartisan judges. We're not talking about just the quote rogue judges. Like this is it just is such a sign of where we are. So anyway, um, with Lindsay Halligan, she is like many. What happened was the person before her served their 120 days, and then it was up to the court to choose. Well, the president took the view, I can just keep doing this 120, so I never have to actually let the judges choose, nor do I actually need to get a Senate confirmed person because I can keep rolling over ad infinitum the 120 days. Well, guess what? The judges who are deciding this are looking at this going, not so much. And
Yeah.
so that's the issue with Lindsay Halligan. There's a second issue, which is there prejudice because of this? And that's where Lindsay Halligan's appointment may be very, very different than other people. So Alina Habba, who has this problem in the Third Circuit, which is in New Jersey, the judge there said, look, she is improperly the U.S. attorney, but I'm not throwing out these indictments because career people were on them. Career people signed them. In other words, there are other people, and there's no reason to think this wouldn't have gone forward but for Alina Habba. That's not the issue with Lindsay Halligan, because do you know how many people were in the grand jury with her presenting the case? Yeah, zero. Do you know how many people signed the indictment other than her? Zero. And how many people from her district, the Eastern District of Virginia, how many of the career AUSAs, or frankly, any AUSA from the Eastern District of Virginia, are on the actual case? Zero. And so that's where there's going to be a problem with her saying, "Oh, don't worry, career people would have done this. I'm just like a figurehead. This all would have happened anyway." Everybody knows there was a declination memo written by career people and by the Trump appointed U.S. attorney. So the idea that there shouldn't be this sort of causal effect of her of if it's found that she's improperly appointed, I think that is what's going to distinguish her case from all the other cases that are around the
Right.
country.
And this is where the vindictive prosecution and the appointment issue kind of merge, because the whole rationale for putting her in there was because the regular prosecutors wouldn't go forward with this. It is
And, and
also,
and the Trump appointed person wouldn't go forward. Eric
right,
Siebert
exactly.
would not go forward.
And for Comey, at least, dismissing this with prejudice would mean he walks because they have a statute of limitations problem. Might not be the
Exactly.
same result with Tish James or others. They could theoretically come back and refile, but for her, that's pretty dead.
Yeah, although yes, if it's on this issue of the wrong U.S. attorney, if with a
Right.
vindictive prosecution, it doesn't
Yes.
matter who the U.S. attorney is. If
Correct.
it's if the idea is if it's
Right.
vindictive, if we're sort of slopping over to that now, that would just kill the case, no matter who the U.S. attorney is.
And how strong do you think a case that is? That part of the issue is.
Well, it is true that it is not a classic case, but it's not a classic case because nobody in their right mind would ever have done this.
Yes.
I'm reminded I once was, when I was a very young attorney, I was a prosecutor and I was arguing something, a mandamus petition in the Second Circuit. And the other side gets up and says, you know, judges, Mr. Weissmann hasn't cited a single case that's really directly on point. And you know what? He was right. I mean, I couldn't find anything directly on point. But one of the judges helped me out and said, well, of course he's not going to find anything on point. What other district judge in the world would ever do this? Um,
Yes.
and so that's part of the reason why the traditional way vindictive comes up is a defendant appeals something. They make a motion and it's embarrassing, let's say, to the government, and they prevail. And then, solely for that reason, there's no new facts, there's no new justification. The government piles on and adds more charges and takes a different position. That's sort of your classic vindictive case. It's very, very rare that it happens, and so it's very rare that these are granted. In this situation, the best argument that Donald Trump could come up with is at the very outset, when I was complaining about Jim Comey, it was about bad conduct. It wasn't about his words. And my answer to that is even if you accept that is true, and I think there's a lot of factual issues with what he's saying, but even if that's true, that early on he was concerned about bad conduct. That's not what's happening now. At the
Yes.
moment that you've got to look at it through time. And if you want to, it's not like if it wasn't vindictive 2 years ago, that doesn't mean he's off scot-free. It's like, was it vindictive in instituting it?
Now,
So
right.
he issues this tweet that, is public, which, there's a lot of speculation it wasn't supposed to be public, to Pam Bondi that says, do it. Lindsay Halligan's going in there. She likes you. She's ready. And
Yeah.
go for it. And we need to do it now because you need the statute of limitations was running. And the issue is at that point, he knew at that point the career people were saying no. He knew his person was saying no, and he was firing that person. And he was putting Lindsay Halligan there to do it. And there's just substantial evidence that the reason for that was that James Comey was insufficiently loyal, um, as expressed by him in his assertion of the First Amendment. And
Right.
so it's retaliation for protected activity. So that's a very long way of saying that I think it is a very, very strong case. In my view, it's sort of if not here, when.
Yes.
And so I think the only issue I see is whether a judge might decide to protect their record, protect their this issue on appeal because you know this is going to go on appeal
Yes,
if he rules for James Comey, and say, I first want to have discovery. I'm first going to give both sides
right,
discovery, which would delay the matter, but it would allow the court to build a more substantial record and also allow the government more, a time to show why their position is right. And
right.
so to me, that's sort of the strategic call, even though I think a judge right now has a very, very good record.
And of course, he might dismiss it on one of the other multiple grounds before we
Oh,
resolve the vindictive prosecution.
yes.
Aside from the appointment timeline, there is now grave question about what she said and what she did. I'm speaking of Lindsay Halligan in that grand jury room. There's some question about what she told the grand jurors, two specific
Yes.
statements. There's a question about whether the indictment got shown to the grand jurors. Take us through those and sort
Sure.
of prosecution 101 for what you're supposed to do and not do in front of a grand jury.
Sure. So first, quickly, a grand jury is made up of civilians, just like a trial
Yeah.
jury. It's 23 people. In order to have an indictment in this country, a federal felony charge, 12 of the 23, a majority, have to find there's probable cause as to the particular defendant and the particular charge. So you go charge by charge and defendant by defendant, and you need to have that majority vote for each one. As has been reported, the first indictment that was presented had three charges, and we understood that there was not a majority with respect to the first, but there was sort of a bare majority, 14 to 9 had voted to go forward with counts 2 and 3, which then become counts 1 and 2. More on that in a moment. By the way, that's outrageous. I mean, the idea that you can't convince a grand jury of probable cause, which is a very, very low standard, think of it as like 20%, even though the law doesn't give it exact percentage, but they have to prove their case beyond a reasonable doubt unanimously, not 12 out of 23, unanimously and beyond a reasonable doubt. So enormous concern that they don't have enough. And that goes to the vindictive part also.
Yes.
Um, so here's the issue. The judge looked at the grand jury transcript, and there's now litigation about whether that transcript will be shown to James Comey and hit the defense team. But the judge said that there are now three issues. And just, when James Comey sees that grand jury transcript, I'm interested, and I think there may be another issue that is important that
Okay.
I see Comey particularly focusing on. But here are the three issues. The first one is that the judge said that Ms. Halligan seemed to suggest that don't worry, there's other proof that we're going to present at trial. So, like, this may not be enough, but don't worry, we have a lot more. And it's as if there's like, you should rely on that. Now, to be fair, with when a witness testifies, a prosecutor may often say to protect the witness because you only are presenting certain evidence, and you may say, Agent Rubin, um, is this all of the evidence that you have collected during your investigation, or have you only brought and talked about some of it? And you say yes. But when you then instruct the jurors, you
Yes.
tell them you can only consider what's been presented.
Right.
Do not speculate about nothing else is before you. The fact that the agent said that is just so that he doesn't or she doesn't get attacked later to say, well, you didn't tell the grand jury that because you don't
Right.
have an obligation to set forth, chapter and verse. So you just want to make it clear what you're doing, but you have to make sure that the grand jury is not misled into thinking, oh, don't worry, it's a very strong case.
Right.
The second thing, so that's one big issue. The second issue, actually, there are four issues. I feel like that old Saturday Night Live thing where it keeps on going more. There's more and more. Um, the second issue is a Fifth Amendment issue where the judge said that in reading this, that Lindsay Halligan said something, we don't know what, it was redacted, that made it sound like James Comey had an obligation to explain himself, which of course he doesn't. You have a Fifth Amendment right. to stay silent. You have a trial right to stay silent. In fact, the judge, for anyone who's listening to this who's been on a jury in a criminal case, the judge instructs you you cannot consider in any way, shape, or form that the defendant hasn't testified. Third issue, attorney-client issue. It appears that when the agents and prosecutor were doing this case, that they did all sorts of things that seem improper to me. One is, well, they got a search warrant years ago in another matter. They then held on to that material and then proceeded to search it in connection with a different matter, the James Comey case, and seemingly went way beyond what this search warrant said. So, really quick thing, search warrants, which are required in order to seize something and search something, will say, Agent Rubin, you can look for items A, B, and C. That means you cannot look for D, E, and F. And when I teach students about this, that means that you cannot look for an elephant in a drawer. So if the search warrant said you can look for an elephant, you can't start looking through drawers. You
Yeah,
have to stay within the scope. It's sort of like, I mean, this is, you don't need to go to law school for this. You have to stay within the scope of what the judge said. Well,
right.
this judge said they didn't do that. They
Yeah,
went ahead and looked at other things. And to make matters worse, the other things included communications between James Comey and his attorney. To me, the idea that there was not a filter team where James Comey had an opportunity to say what is or is not privileged is is something where there may at the end of the day be no prejudice from it, but in terms of the violation of attorney-client privilege and the sloppiness, I mean, this is what happens when you fire competent people what up one side and down the other because of Doge, because of Pam Bondi, because the president is like saying get rid of everybody, and then you have people who don't know what the hell they're doing, and that's the
right.
polite term.
Right. A filter team, just to be clear, are people who are not otherwise involved in the case, are not going to testify, are not going to present the evidence. They are brought in for the sole purpose of determining is there a client, attorney-client information.
When I was head of the fraud section, we that was a standard part. We had a sort of standing filter team. When I worked on the Mueller investigation, the woman who had been doing that, who was so excellent, we brought her on not to be a part of the Mueller team, but to do the filter review
Yes.
with separate attorneys, separate agents. When we did a search of Paul Manafort's house, Paul Manafort is not a lawyer, but we thought he may have had communications with lawyers because of the time period we were looking at. We did not do the search. That was done by the filter team, and they
Yes.
dealt with. And I remember calling his counsel and saying, "This is what's happened. Here's the telephone number of the attorney. Deal with it because you're going to be invited to look through everything and tag
Right.
what you think is privileged." That's what you do. For two reasons. One, it's the right thing to do because you don't want to invade somebody's attorney-client privilege. And two, as a self-protective matter, if you don't do that, it's only going to hurt your case.
Right. Right. Yeah.
Okay. Are we going to get to the and now
Yes.
there's the
Now
issue,
the big
right?
reveal.
Right. Is like so there's a court appearance where a big thing that happened is remember we talked about there was the first indictment with three charges, but the we were told the grand jury sort of rejected one but voted for two. But then there's the second indictment, which is called a superseding indictment, but it's a second indictment. It, I mean, indictments are just there's one indictment, then there's another indictment. Those both can coexist, and it's not unusual to have cases where there's one indictment and then the government supersedes and adds things or subtracts things. Um, so the issue is after the grand jury said no to count one and seemingly said yes to count two, this second indictment appears. And at the hearing that was just held, Lindsay Halligan and the AUSA, who is now on the case, not from the Eastern District of Virginia, both said that second indictment was not presented to the grand jury. It's what I call the immaculate conception of it just appeared. And the judge
Yes,
is like, what do you mean it just appeared?
right,
Because the normal procedure is when if the grand jury says no to one count, but you want to then have one clean instrument,
right.
one clean indictment, is you go back to the grand jury with just what they are likely to approve or what you think they have approved based on what they told you, and you present just those two charges. They read it, they deliberate, and they vote on it. One thing to note, um, in the grand jury, there is a prosecutor, there is no judge, there is no defense lawyer, there are grand jurors, and there's a court reporter. Now, um, that is the standard practice when a prosecutor is speaking to the grand jurors, is giving them instructions. But then, if you're going to call a witness, and here they called one agent, a witness can come in, the testimony is taken, the witness is excused. Um, so that would be one additional person who's in that room. At the moment that the grand jurors are ready to deliberate, it's like a trial jury there. Everybody leaves other than the grand jurors. There's no court reporter and there is no prosecutor. It is just the grand jurors, and they deliberate, and there's no record of it in terms of there's nobody taking down what they're saying, either in a tape recording or in a transcript, just like a trial jury. And then when they're ready, they come out, and usually the foreperson comes out and brings the prosecutor in, and you're then back on the record with the court reporter. Everything that you do as a prosecutor is on the record. It is transcribed, uh, beginning to end. It is both the right thing to do, it is the self-protective thing to do. You want no question. So here, the issue is, um, what happened? How did the second indictment come to play? Like, how did that come about? And what happened in court is Lindsay Halligan and the trial attorney say, no, the second indictment was never presented to the grand jurors. Just the second one. Um, the next day, the government files something that says, no, yes, it was presented. By the way, there's no record evidence of that at the time, no contemporaneous one. They're relying on a statement by the foreperson. When an indictment is issued, it is handed up to a judge, and the judge is sort of trying to figure out why she has two indictments here. Both are signed,
Yes,
and she's like, "What's going on?" And they seem inconsistent, and one has three and one has two. And the foreperson says, "We voted on these two counts to go forward on these two counts," but it's unclear whether he was trying to say the grand jurors all saw the actual second indictment or not. So
but
so there it's a
just
mess.
to say, Lindsay Halligan in open court yet yesterday on Thursday, was it Thursday, Wednesday, whatever day it was, said no, it wasn't presented. And now the government is saying yes, it was. How did they do
Yes,
that?
it's unbelievable. But can I just say, like, it is a shit show. It is gross incompetence. But let me just say why I think
Sure.
this is evidence of incompetence, but I don't think it is going to make a difference and under the law.
Okay.
And that is the following. There's two reasons. One, we've been talking about these two indictments. Well, big if the grand jurors saw the first indictment with the three charges and they voted on it, and
Yes.
they voted no to count one, but yes to count two and three, like if they actually read it and voted on that, and there could be a hearing to make sure that is what happened, then those two counts, regardless of whether it's in the first or second, I mean, this
Yes.
for like take the second one off the table. Just go to trial then on the first indictment
Right.
because you have the grand jury having voted on that. yes, it is a total shit show that as to what they did and count on the second indictment, but it's sort of irrelevant. And let me give you one more reason. Statute 18 USC 3288. Sorry to be total nerdy, but that is a statute where Congress has said where the statute of limitations has run, like you indict somebody within the statute of limitations, within the right time period. Then the defense challenges the indictment for some technical reason, unrelated to the statute of limitations. Like they say, something was improper. That statute gives the government 6 more months
Yeah.
to bring the charge. And the reason for that is it's otherwise unfair to the government, absent sort of extraordinary circumstances, because the government's thinking, you know what? I don't have to. I let the statute of limitations run, but I did it because I thought this was a totally valid indictment, and so now the court disagrees. But it's unfair. I obviously would have presented it and cured whatever technical issue there was, and so the government still has a lot of between that and the issue of whether count one was really voted on. I mean, the first indictment was really voted on, gives the government a lot of play here. Can I give you just a third practical sort of reason?
Absolutely.
It would be nice in this case where what is really going on is vindictive prosecution to have a ruling on that. I
Yes.
know from
Yes.
Jim Comey's point of view, he may be like, I don't care what the reason is, like, and that's fair. I mean, he is the one who has been targeted here. But from a nationwide perspective and what DOJ is doing and what the president is doing,
Yes.
it would be very useful if the judge thinks there was vindictive prosecution to say it and
Right.
to not have
Right.
him not to have him go off on a what would be I don't want to call it a technicality, but something that's not the heart of the issue
Right.
that you could repeat and repeat
Right.
itself.
Now, question. And when I saw this whole thing, I thought exactly as you did. Well, the first indictment lives on. There really isn't a superseding, it doesn't go poof because you
Right.
brought in a second one. Why didn't Lindsay Halligan just leave it alone and send it up with them?
Be, well, so what you're supposed to do is you're supposed to present a clean indictment.
Okay,
And the reason is otherwise what the judge gets is an instrument that can't go to the jury. It's like
got it.
because there's now three charges, one of which that is wrong, and it also unnecessarily disparages the defendant because the
Right,
defendant the like imagine it was this. Imagine the first count was murder and the next two were um he was speeding and
shoplifting or whatever.
and
Yeah,
shoplifting, and the grand jurors say he didn't commit murder, like we don't find probable cause, but that means it shouldn't be made public. It should, and so that's why you're supposed to do this thing of presenting a
right,
clean one. And there is an argument that regardless of what they did on count one, if you're going to go forward on count two, I mean, on the second indictment, you should present it. You should have the grand jurors
right,
decide. But you
right,
know what? It's very, very technical because you know what? You could always take that first indictment and redact the part that shouldn't be made public.
right.
Meaning you could just, it's like it's take big black marker. It's like what you see when the judge said, "I'm redacting what Lindsay Halligan said in the to the
Right.
grand jurors."
Now, what is going on right now? The judge is ruling on whether the grand jury transcript itself can be turned over in unredacted form to Jim Comey. If
Yes.
he says yes, at that point, can the U.S. attorney take that up on interlocutory appeal or they have to go forward?
That is a good question. I don't see why I I'm just thinking out loud. I don't see why that is an interlocutory appeal.
Right, because
The
what
issue
prejudice would there be to the
it's
prosecutor?
it's
Yeah,
that's a discovery matter. It's not a privilege matter. I don't see that. The reason you can go from the what the magistrate said to do to the district judge
right.
is because that's automatic. A magistrate
Yes,
judge is not an Article 3
Right.
full federal judge. The way I like to think of it is one person is the chef and the other person is the sous chef.
Right.
As you can tell, I like food. Um, and so there you have an automatic right. There's no doctrine of, oh, you don't get to appeal everything. Now,
Exactly.
can I just say the thing that I think the reason I really want to see if James Comey's attorneys get that grand jury transcript, I think that
Yes.
there's a good chance there's going to be more that's
Yes.
problematic. And
Yes.
you
Because she
may
didn't
have,
know what the hell she was doing. She had no
yes,
idea what she.
and there's a very technical issue here that is super important because it isn't it's technical, but it goes to the substance. The lie at issue, and I'm just going to cut through a lot of like other pieces, but the lie at issue requires that Dan Richmond, the attorney who allegedly was the cutout, it requires that he actually be an FBI employee.
Right.
And if you look at what the government did in their briefing, they put on a sort of kitchen sink splat of evidence that included things that Dan Richmond did before he was at the FBI, during the time he was at the FBI, and after he was at the FBI. And to my mind, one of the things that was there and was presented by the government after he was at the FBI seemed the most incriminating. Not dispositive, but the most incriminating. But it's not direct evidence. It's not because it's after he was at the FBI. And why is
Right.
that time period important? It's because James Comey, when he was asked the question, was asked, did you use a cutout of somebody at the FBI? So if
Right.
Dan Richmond was not at the FBI, it doesn't matter because he wasn't asked about it. I mean, you might not have liked that he was a cutout before or after, but that wasn't the question. And
Right.
so do you how much like Jen, what do you think the odds are that Lindsay Halligan was attuned to that issue and instructed the grand jurors and the agent to be really careful about
And just
what
do the
the
right timeline.
evidence is. And this
Right.
is the timeline. And by the way, if you talked about X, you cannot consider it as direct evidence. I just find that hard to imagine. I could be wrong, but I
Right.
think that's one of the things that I could see why a magistrate might not be as attuned to this yet because it hasn't really been
Right.
briefed. But you know that James Comey's lawyers are going to be all over this, like a duck on a
Yes.
June bug.
Yes. Well, I think, needless to say, you may get your wish. On the other hand, there are so many other screw ups in this. If a judge doesn't want to take on the vindictive prosecution, which is really accusing the president of the United States of weaponizing and abusing the entire judicial system, he's got a smorgasbord of reasons. He can take
But
one and two, he can take one and three and four. There's a lot of
well,
other stuff
Belton's
that,
yes, but he also could do belt and suspenders, which is,
yes,
it's like,
yes.
there was an excellent judge in the Eastern District of New York, Rena Raji, who used to do that. It was just like, she created a very good record. And to her credit, what she was doing is saying, look, when this gets appealed to the Second Circuit by whoever it is, by the defendant or by the government, I want the circuit to have the benefit of all of these rulings so they doesn't have to keep bouncing back and forth. And so you could have a judge saying, here are, I find on this, I don't find on that, I do find on this, but like to go through it all.
Exactly. And we could have like a Guinness Book of World Records of number of reasons why a US attorney has fucked up, excuse my language, and therefore James Comey gets to go home.
Yeah, and I for people who are listening to this who think this all sounds really complicated and technical and there's a lot of ins and outs, I want to make sure people understand that in my world, in it when you are have any experience as a prosecutor or a defense lawyer, and a lot of prosecutors have been defense lawyers and defense lawyers have been prosecutors, the things that we are seeing don't happen. And even if one of them happens, the confluence doesn't happen. I mean, it is unbelievable. Maybe there'd be an attorney-client issue, but there'd be an attorney-client issue at the same time that you violate the search warrant. At the same time that you appear to suggest that James Comey should have to testify, at the same time that you're suggesting, oh, don't worry, I have lots of other evidence you can rely on, but I'm not going to tell you about it. I mean, again, assuming that what the magistrate judge said is true. I mean, the confluence is staggering,
Yes.
staggering.
Yes. And it does go to the issue that you stated, which is once you throw out all the competent people, things like this happen because you have people who literally do not know what they're doing. And this was complicated by the fact that no one would go into the grand jury with her because, of course, none of them in that office thought that there was a case because there had been already a declination memo that said there was no case. So that's why she went in there herself to make all these mistakes.
But
I mean,
Jen, could you know Washington, and so the Eastern District of Virginia is across the river from Washington, D.C. Do you know what's
yes,
in Washington, D.C.? Hundreds of Department of Justice prosecutors,
yes, I know.
hundreds. And so, like, yes, Lindsay Halligan should have found somebody, but like, I'm sorry, but Pam Bondi and Todd Blanche didn't have one experienced person who could go with her. Could I just say, could you imagine? I'm a new prosecutor in the Eastern District of New York. That's where I started my career. Could you imagine if the U.S. attorney said, "Yeah, just on day three, just hop into the grand jury. We're not going to train you. Just
Right.
good luck." I mean, the first time I went to the grand jury, not just the first day, I think it was several, like people are with you. Senior people go with you.
Yes.
You do your first trial with a senior person. You do your second trial with a senior person. You do your third trial with a senior person. Why? Because you want to make sure that you do this right, and it's serious business.
Yes, it's
People
people's
go to jail.
lives.
Exactly. I mean, that's
It's,
what's it's unbelievable. The callousness, the incompetence, in my view, the vindictiveness. It's just such an incredible confluence of not just errors, but what it reflects about what you think about the rule of law in this country.
exactly. It's just contempt. They don't take it seriously. This is just, you know, all this nicety they don't care about. It's just
Right.
get their guy. Well, thank you as always, Andrew, and thank Ines, who I think popped up to make a short
Yes.
appearance there. We
Yes.
always love seeing Ines. So thanks so much, Andrew. We will look
Yep.
forward to seeing you next time. Bye
And
bye.
and stay tuned for what's going to happen.
Exactly. Exactly. Take care.